Thank you, Mr. Professor. Thank you all. Good morning, nearly good afternoon. First of all, I would like to thank you for the opportunity to participate in the research program, which, in my opinion, plays an exceptionally important role from the point of view of the Polish justice authorities. The title of my speech is The Activities of the Public Prosecutor's Office in the Era of Crisis of the Rule of Law in Poland. The latest Public Prosecutor's Office Act was introduced into the national legal system by the Act of January the 28th, 2016, and was related to a constitutional change involving the restoration of the function of the Minister of Justice as the Prosecutor General. Under the previous Act of 2010, the functions of the Minister of Justice were separated from those of the Prosecutor General. Currently, the Act consists of 9 sections devoted to, among other things, general provisions, including the task of the Public Prosecutor's Office, activities that must be performed by prosecutors, the independence of prosecutors, and the powers of superior prosecutors to amend or revoke the decisions of subordinate prosecutors, the organization of the Public Prosecutor's Office, the activities of the Public Prosecutor's Office in preparatory proceedings, court proceedings, and others. Prosecutors, including the appointment and dismissal of prosecutors and their basic duties, and the criminal, disciplinary, and professional liability of prosecutors and others. The law on the Public Prosecutor's Office was criticized by some representatives of the prosecutorial community, as well by certain politicians and not governmental organizations. Among the shortcomings of the acts were mentioned reduced independence of prosecutors, centralization of the authority and political supervision, ambiguity of certain provisions, including those concerning access to case files, supervision and control, as well as issues related to the delegation of prosecutors to remote location within the territory of the Republic of Poland. In connection with the introduction of the new provisions, the legislator was forced to adapt the organizational structures of the prosecutor's office and assumed that due to the fact that the act on the prosecutor's office had been amended many times, it no longer met the needs for modern state governed by the rule of law or the challenges associated with the development of technology and various types of crime, in particular those of a terrorist nature or organized financial and economic crime. The drafters also pointed out that the separation of the position of Prosecutor General and Minister of Justice has led to the Prosecutor's Office losing its real influence on the functioning of other institutions directly related to it, including the Institute of Forensic Research in Krakow and the National School of Judiciary and Public Prosecution, which trains new prosecutors, but not only prosecutors, but also, of course, judges. At the same time, the Prosecutor General became one on many central public authorities. Equating the position of the Prosecutor General with that of other hand on central authorities created problems with cooperation. Under the Act, the position of Minister of Justice was merged again with that of Prosecutor General, who thus became the supreme authority. Article 1 of the Act provides that the Public Prosecutor's Office shall consist of the Prosecutor General, the National Prosecutor, other deputies of the Prosecutor General, and prosecutors of the general organizational units of the Public Prosecutor's Office and prosecutors of the Institute of National Remembrance Commission for the prosecution of crimes against the Polish nation, hereinafter referred to as the Institute of National Remembrance. The National Prosecutor became the first deputy to the Prosecutor General, while for the other deputies to the Prosecutor General, positions were created for organized crime and corruption and military affairs and others. The remote departments for organized crime and corruption were transferred to the level of the National Prosecutor's Office. An important change concerned the appointment and dismissal of the National Prosecutor, as well as other deputies of the Prosecutor General. Pursuant to Article 14, Paragraph 1, of the Act of the National Prosecutor's Office, the National Prosecutors, as the first deputy to the Prosecutor General and other deputies to the Prosecutor General, are appointed from among the prosecutors of the National Prosecutor's Office and dismissed from these functions by the Prime Minister at the request of the Prosecutor General. The National Prosecutor and other deputies of the Prosecutor General are appointed after obtaining the opinion of the President of the Republic of Poland and dismissed with his consent. I want to emphasize that such actions required the consent of the President. There was an increase in effectiveness of prosecuting crimes by almost 3% in the first year after the introduction of the Act and organizational changes. An important aspect to note was the dismissal of January the 12th, 2024 by Minister of Justice and Prosecutor General Adam Bodnar of Dariusz Barski, the National Prosecutor. The Minister of Justice cited the ineffectiveness of reinstating him to effective service, given that he had been retired before taking up the position of National Prosecutor. In his decision, he stated that the reinstatement of Prosecutor Dariusz Barski to service on February the 16, 2022 by the previous Prosecutor General was carried out in violation of the law due to the application of non-existence provision of an incidental nature. At the same time, it should be noted that contrary to Article 14, Paragraph 1 of the Act of the Public Prosecutor's Office, the Prosecutor General did not obtain the relevant and absolutely required opinion of the President of the Republic of Poland before dismissing the National Prosecutor, relying instead on external legal opinion, which are not, of course, source of law in Poland. As a result of examining cases concerning, among other things, the correctness and effectiveness of the dismissal of the National Prosecutor, the Constitutional Tribunal, and the Supreme Court confirmed in the ruling that the dismissal of the incumbent National Prosecutor was ineffective. The decision of the Minister of Justice, Prosecutor General, caused chaos in the Prosecutor's Office and led to unimaginable negative legal consequences related, among other things, to sentencing and the possibility of challenging decision issued by unauthorized prosecutors, including the current National Prosecutor. In the era of crisis of the rule of law that we currently witnessing in Poland, it is impossible not to notice that institutions such as Prosecutor's Office and the courts, which find themselves in a legal stalemate, play a particularly important role in ensuring stability and legal protection. How then should the public prosecutor's office function, given that according to the Constitutional Tribunal and judges of the Supreme Court, the national prosecutor was dismissed unlawfully without the consent of the incumbent President of the Republic of Poland? The legality of the functioning of the National Council of the Judiciary is also being questioned, with some judges being referred to in an offensive and unauthorized manner as neo-judges, forgetting that they were properly appointed to their position by the president. The situation has caused outrage not only among prosecutors, but also among judges, and its consequences directly affect citizens seeking justice where it proves impossible to find. The legal consequences of the so-called dual power in the prosecutor's office can lead, and indeed do lead, as we have often witnessed, not only to the questioning of the correct appointments of the prosecutors to their current position, but go even further, namely to the questioning of court rulings. An example of actions that anarchize and destabilize the current legal system is the latest initiative of the Minister of Justice, the Prosecutor General, who as he quote, recognizing the need for law and standardization of prosecutorial practice and ensuring the parties' right to an independent and impartial court established by law. End of quote. Instructed the national prosecutor to develop guidelines obliging prosecutors to examine in each case whether in specific circumstances the participation in the court of a person appointed to the office of judge on the basis of a motion by the National Council on the Judiciary does not violate the requirements established by the Constitution and international agreements binding on the Republic of Poland. In response to the above initiative, a legal opinion was prepared by the Trade Union of Prosecutors and employees of the Prosecutor's Office of the Republic of Poland, which criticized these proposed guidelines, in particular with regard to doubts about the independence of the prosecutor's office, and in particular due to the established practice of their redundancy and even irrational nature. Given the current situation, we must ask ourselves a purely rhetorical question. Should the current justice system be based solely on the individual courage of individual prosecutors and judges who oppose creeping legal anarchy rather than legal grounds? Let us hope that the situation will be resolved in the near future, thanks in part to the involvement of the current president of Poland, because otherwise the legal chaos will continue to deepen, and as consequences citizens will suffer, not to mention the impact on Poland's image on the international stage. Thank you for Chair.